Good evening and welcome to the latest in CUHK Law's Property Law Seminar Series. My name's Stephen Gallagher and it's my pleasure to welcome you to the seminar tonight with my colleague, Professor Michael Lauer as well. So tonight, Michael and I are going to be sharing the seminar. I'm going to start and I'm going to be talking about destroying property. And then Michael's going to follow up and talk about adverse possession and claims to property. There is a link between the two in the public policy side. So hopefully there'll be something to interest everyone in the seminar tonight. So hopefully you can see my slides. The title I gave this was, Can You Destroy Your Sex Pistols Memorabilia, Your Non-Fungible Token and Your Van Gogh After Your Death, because of some notable cases that I'm going to talk about. But actually we need to start with the basic question, can you destroy your property? And of course, for many people, the answer would be, well, of course I can. You know, one of the main instance probably of being a property owner is the ability to destroy property. It's probably a good indication that you are an owner of property if you can destroy it. But the real answer is, well, possibly you can destroy it because there are some limitations on being able to destroy your property. The first, of course, is you must not damage the property of others when you destroy your property, and you must not cause a nuisance. I'll talk about each one of these in turn briefly. The second is more interesting to me. You may be prevented from destroying certain forms of property which society considers worthy of protection. That sort of special property. For me, I'm thinking mostly of art, monuments, antiquities, and cultural heritage. So we'll be talking mostly about art. And then the limitation that really comes into the title is there's also a limit on being able to destroy your property after your death as well, testamentary destruction of property. So for the first one, yes, you can destroy your property usually while you're alive, but you have to be careful about other people's property. So in Pennsylvania, there was an unfortunate incident a couple of years ago when someone was trying to demolish a property or parts of a property. And of course, they could do that to their own property, but unfortunately everything went wrong and they demolished the neighboring property as well, which of course then leads them open to various legal actions. There's criminal action, criminal damage could be involved. Civil actions, of course, action for property damage, and we could be looking at the torts of negligence and or nuisance as well. But let's start thinking about special property, because I think that's very interesting. When we sometimes think that property is so special that we should give some legal protection to prevent even the owners of that property from destroying it. Well, one form of special property that we often see, at least in films, being destroyed is, of course, when people burn money. And of course, there are laws in most jurisdictions which actually protect the currencies of those jurisdictions. In the United States, it's quite a serious offense to burn money, by the way. So if you're ever tempted to light your cigar with a US dollar bill in the United States, you have to be careful. It's quite a serious offense. It's okay to burn this money. Of course, this is Chinese joss money or hell money, and it's all part of a ritual. In Hong Kong, we have limits on some special types of property, some protection, and that comes into our Antiquities and Monuments Ordinance. This offers a dual mode of protection. It protects antiquities and relics automatically if they are identified under the definition of antiquities and relics in the ordinance. And then we have protection by designation by a government officer, at present it's the Secretary for Development, when something is identified as a proposed monument or a monument in Hong Kong. So the antiquities protection, the relics protection, well, that is if we can identify something as an antiquity or a relic, and we have the definitions in the ordinance. A relic is an antiquity. An antiquity is also a place, a building, a site, or a structure. Really, we're looking at things that were made before the year 1800, which are discovered in Hong Kong. If something fits that description, well, then there is a duty in the ordinance which really provides the protection, a duty to report this to the relevant authority, and also any relic, anything created by man after the year, before the year 1800, discovered in Hong Kong, belongs to the government of Hong Kong. So any antiquity and relic discovered in Hong Kong would be protected as property of the government. But then we've also got a designation for protection as well, which is our monuments and our proposed monuments. And if something is identified as a proposed monument or a monument by the Secretary for Development, then, well, lots of protections occur at that point as well. Even if the building or the site that is identified as a monument is privately owned, well, then that private owner can't do what they like with that property anymore. There is protection afforded in different measure to the building, to the site. So they won't be able to renovate, they won't be able to knock down any of the property or dig holes even in the ground at times without getting permission from the Secretary for Development. So you can't do what you like with your property if it's identified as a monument or a proposed monument, or if it fits the description of an antiquity or a relic in the ordinance. However, if it doesn't fit any of that, well, really, we're free to do what we like with our properties. And we see this even with buildings which a lot of people feel should be protected in Hong Kong, such as Houghton Gardens, which of course was subject to a huge debate about its future back in the early 2010s, which ended in the end in 2013, of course, with the owner demolishing the property, which of course was her right, as it was her property, and there was no statutory protection for it. I think there is another way that actually protected property could be protected, and even an owner might not be able to destroy property themselves, and that comes under the protection afforded to artists and their work. The Berne Convention, of course, many jurisdictions are party to this. Hong Kong is through China. The Berne Convention provides for what are known as authors' moral rights. Sometimes they're referred to as artists' rights as well. And that is the right to claim authorship of the work and the right to object to any distortion, mutilation, or other modification of, or other derogatory action in relation to the said work, which would be prejudicial to the author's honor or reputation. So distortion, mutilation, other modification, I think that could afford some protection against destruction, but there haven't been many cases, at least in Hong Kong, to do with this. But we do get lots of examples of owners actually destroying their art, their antiquities, and their cultural heritage. They do so for various reasons. Often it just boils down to the fact that they no longer like that particular object. But there could be other reasons. Sometimes we've had owners of art destroying artworks because then it makes other artworks by the same artist or of the same type more scarce and therefore more value. We've also had, of course, people destroying property for political or social protest. But again, one of the things I think that could interfere with this ability to destroy your own property is the fact that artists' rights might come into play if we have living artists or even artists who are recently deceased. Artists themselves, of course, may destroy art as well. Often that's because, well, they just don't think it's good enough. It represents a good piece of their work. And many artists, of course, have been very critical of their own work, but also sometimes they destroy art to create art itself. So let's think about a few examples of people destroying art and their antiquities and cultural heritage. One of the most famous destructions of an artwork occurred in New York in 1932, which was this mural. We have a few photographs of the partially completed mural by Diego Rivera, which had been commissioned by the Rockefellers for the new Rockefeller Center in Manhattan. Now, of course, the Rockefeller Center are sort of a temple to capitalism. It's a strange choice of the Rockefellers to choose a socialist artist to actually paint a mural, but they do. And of course, he starts to paint this mural, and friends of the Rockefellers actually draw their attention to the fact that, well, if we look to the sort of mid-right there, you might see the face of Lenin looking out this mural. And there are other socialist icons in there, and there are also examples in the mural of capitalist oppression as well. So we've got socialist message being painted in the middle of this huge temple to capitalism. The Rockefellers, of course, asked Rivera to change various things. He refuses. So they send in their workers in the evening and they just paint over the mural, and we lose an important work of art. He did paint another version afterwards, but a lot of people at the time criticized this. At the time, the laws didn't affect this, didn't offer any protection. In America now, they actually have some laws which probably would afford protection for this, but it's an example of owners deciding that they no longer want this work of art and destroying it. We also get examples of owners destroying artworks because they want to increase the value. So this is, I'm not sure if there are any philatelists out there, but this is the magenta 1 cent Guyana, the rarest stamp in the world. It's very difficult to get a value for this. People estimate it's worth in excess of $5 million US, but of course it doesn't come onto the market, so it's difficult to know how much it's actually worth. It is unique. It is the only one in the world, and that, of course, is why it is so immensely valued. But the story goes that the owner of it in the 1920s was the US industrialist Arthur Hind, and he had managed to find a second copy of the stamp, which existed, well, not for very long when Mr. Hind got it, because of course he knew that 2 copies of the stamp made those stamps not unique, not so rare. They would be rare, but actually, as he said, when he burnt the stamp, apparently there's only 1 magenta, 1 cent Guyana. Again, nothing to protect, nothing to stop him. It was his property. He could destroy it if it happened, because again, there are doubts about the story. We've also seen in recent times destruction of art and what we might describe today as heritage for political and social protest by the owners as well. So in 2016, Joe Corey, who was the son of Vivienne Westwood and Malcolm McLaren, the manager of the Sex Pistols, he famously rented a barge in the middle of the Thames in London, loaded up all of this memorabilia to do with the Sex Pistols and the punk movement generally, but highly collectible, highly prized memorabilia, apparently amounting to some £5 million worth, and promptly set fire to it as a demonstration because he was upset with the UK's social system. So we get this destruction of work. At the time, again, attracted a lot of attention and a lot of opposition. People saying this is, these are important symbols of our heritage. The Sex Pistols themselves, well, that didn't attract much attention from them. And actually, I suppose the punk movement was all about destruction anyway. So perhaps they would have favoured what he was actually doing in destroying this. Artists' rights, though, may affect the right of owners to destroy their art. At present, we mostly see this happening in the United States, where we have the idea of the moral rights of authors and artists have been given more, well, legislation to actually back them up. So we get stories coming out of the US where the law does actually interfere with the private property owners' rights to actually destroy property and property containing artwork as well. So here we have 5 points in New York. The owner of the site invited local graffiti artists, street art artists to come in and sort of decorate the building. And it became a sort of hub for graffiti and street art and became very famous. It attracted a lot of attention. And that led to the fact that the site actually was subject to more attention and probably worth more money. So the owner then decided that he was going to do some development of the site. That meant that the artwork would go. The artists then objected, and they tried to use these laws to actually object to him being able to do anything with the site. They wanted an injunction to stop him from actually working on the site. Before anything could be done, he'd sent in his workers to actually paint over the graffiti. Now, in America, of course, as I said, they have this legislation which actually protects the author's rights at that point. And the artist sued and won millions of dollars in compensation for the destruction of their art, even though, of course, this was the owner of the building, really, well, probably affecting his normal rights as the owner of the building. So it's an interesting contrast between authors' rights and the owner's rights is there. Artists have often destroyed their art. The 2 main reasons being, of course, that they don't think it's good enough. They're not happy with their own creations, so they destroy it because they are disappointed with their art. And then the other one is, of course, we've had artists who've actually destroyed to create art. So famously, Picasso was meant to have said the urge to destroy is also a creative urge. Banksy recently quoted that again, but actually it probably was Bakunin who actually said that. Artists who destroyed their art, one of the most famous is Claude Monet. He famously destroyed 15 of his incredible water lily paintings in 1908 because, well, they were due to go on an exhibition in Paris. It had taken 3 years for him to create the works, to organize, to curate the exhibition. Everything was ready to go, and he just didn't like these paintings. So he attacked them with a paintbrush and a palette knife and destroyed 15 of these, well, what today are considered some of the most important artworks of the Impressionist period. He was constantly disappointed with his own works. And just before he died, he actually enlisted the help of his stepdaughter to actually destroy some 60 paintings in his student as well. So he destroyed these works and famously was meant to have said, "My life has been nothing but a failure, and all that's left for me to do is to destroy my paintings before I disappear." But artists also sometimes destroy art to create art. So here we have the artist Ai Weiwei, who famously purchased this Han Dynasty vase or urn, as he describes it there, and then took time-lapse photography of him dropping it and destroying it. And of course, that is now recognized, these photographs, as a work of art, a commentary on the art and antiquities market as well, and a very important work by I, so they're very well known. However, I wasn't so happy when another artist destroyed a vase a few years afterwards, because of course, this was one of I's vases, which was on the display in a gallery in America. And there, a South American artist, young man, walked in, saw the urn, saw these vases on the floor here. I don't know if we can see them just over here, and picked one of them up and dropped it. And of course, when he was promptly arrested and charged with criminal damage, he said, no, I'm an artist, and this is art. Destroying this vase is art. And of course, he said, I was actually, following the inspiration of Ai Weiwei. If we look just behind there, you can see those photographs of I dropping a Han Dynasty urn that actually the young man said, these were my inspiration. I don't think the judge was all that happy with his excuse. And I himself, famously very liberal in many ways, well, he wasn't very liberal here. He said, smashing $1 million vase in the name of art is justified if you own the piece, but not if you don't. I bought that vase, I destroyed it. This man did not own the artwork. That's not art. Of course, I think there are many artists in the past would have disagreed with him, because again, much art was, of course, protest as well. We also see destruction by the artist when it's no longer theirs as well, in a very, very famous case, which attracted worldwide attention as well. So an artist creates an artwork and then sells it and then destroys it. This, of course, was Banksy back in 2018, where we have one of these screen prints of Girl with a Balloon, which is offered for sale in Sotheby's auction house in London, in a very strange frame. It doesn't really suit the artwork. It's a very cumbersome frame compared to the artwork as well. And of course, that's because inside the frame is concealed a shredder, which is to shred the artwork. And when the hammer comes down, the auctioneer brings the hammer down, the shredder goes into operation, the painting falls and half shreds. Apparently it was meant to shred the whole thing. Now, of course, that's interesting for lawyers to think about, because if we think about this, when the hammer comes down, the idea of the auction is that at that point, the buyer is then responsible for this artwork, even if it hasn't been paid for. Risk in the artwork has then gone to the buyer. And now we've got the artist destroying something which technically doesn't belong to them anymore. It belongs to the buyer. So the buyer, of course, could have instigated some sort of criminal prosecution against Banksy for criminal damage. It's criminal damage, it's deliberate damage of the artwork, or of course sued him for damage to the property as well. But of course, then you would be looking for damage. And even though the painting is damaged, the value wasn't damaged. The painting sold for £1 million at that time. And of course, because of its fame, last year sold for £16 million. So it's very difficult to really sue Banksy for damaging, at least monetarily damaging the painting, when it actually ends up being worth 16 times as much because he's destroyed it. For me, one of the most interesting aspects of destroying property is this idea that people sometimes attempt to destroy their property after their death. This is the idea of the dead hand, the mortmain, the grasp of the dead hand from beyond the grave coming out to control property and perhaps make it inalienable, to destroy it in some way. The general idea is that there is a problem with trying to, get your property destroyed after your death. If you are going to write into your will that you want property destroyed, will that be enforceable? Will your executors be made to do this? Well, usually no. The courts will usually say no, we won't destroy property. Why? It's considered to be capricious, whimsical or nonsensical, as it says there. The courts will not enforce provisions in wills which are capricious, and they may strike them down. In fact, the Law Commission of England described this power of the courts as the court's jurisdiction to strike down grossly unreasonable testamentary provisions. And it really follows on from that idea, as it says at the bottom, that the court will not compel the carrying out of purposes that are absurd, abhorrent, or a waste of the assets of an estate. And that idea, the waste of the assets, the waste of property, that's really a sort of public policy argument that this is wrong. So there is a difference between what you can do to your property while you're alive and what you can order to be done and will be enforced after your death. However, many people do leave orders to destroy their property, particularly artworks and treasures, after their death, or even to have them buried with them. And of course, there's a long human tradition of burying treasures with the dead. So of course, we think of these amazing treasures that were buried with kings and pharaohs and emperors in the past. More recently, we've had examples of people who weren't happy with artworks and wanted them destroyed after their death. And rather than leave instructions in their wills, perhaps they had some advice that this wouldn't be a good thing. They gave instructions to people they trusted. And we have the example here of Churchill, Winston Churchill, who famously hated this portrait. This is a portrait painted by the artist Graham Sutherland, given to Churchill as a gift from a grateful nation by the people of Britain. And Churchill hated it. As he said, it made me look half-witted, which I ain't. So he never liked it, kept it down in the basement of his house, and apparently had told his wife that he never wanted anyone to see that painting. When he died, she took it from the basement, she took it into the garden, and she threw it onto a bonfire and burned the painting. So if you do want to get something destroyed after your death, you need someone you trust to carry out those instructions. Other issues, the idea of interring things with the deceased and losing them in that way is also problematic. So famously, a Japanese industrialist who in the early 1990s purchased these two very famous Impressionist artworks, a Renoir and a Van Gogh. Well, when he was asked at the time why he'd paid world record prices for these two paintings and what he was going to do with them, he said, "I've got a lovely mausoleum, and when I die, I want them interred with me." Now, he afterwards said that he was joking, but people took it very seriously because they were saying, this is terrible. We'll lose these great artworks. Surely the law will in some way prevent him from doing this. And of course, there is a problem. The law doesn't actually prevent the family from actually interring anything with Mr. Saito. Anyway, of course, shortly afterwards, he falls from grace. He's arrested. He goes to prison. He loses much of his money. He does die, and he is interred in his mausoleum. And those paintings have never been seen since. So we're still not sure what happened to them. There is, of course, a rumor that when he lost his money, they had to be sold anyway. So perhaps they're in another private collection, and they will resurface one day. A number of artists have actually left instructions to destroy their art. Famously, Kafka left instructions to his literary executor, Max Brod. He'd left all of his property, all of his writings in his will to Mr. Brod, and previously had sent a letter to him saying, "Dearest Max, my last request, everything I leave behind me in the way of diaries, manuscripts, letters, my own and others, sketches and so on, to be burned unread." Luckily for us, I suppose, Mr. Brod did not do this. In fact, of course, Kafka wasn't very well known during his lifetime. Brod published everything after Kafka had died, and things like The Trial and other important works by him. It became very, very important body of work in literature. And of course, we wouldn't have the word Kafkaesque without Mr. Brod disobeying his friend's instructions. We have had some successful examples of destruction by instruction. Philip Larkin, the British poet, asked for his diaries to be destroyed after his death, and his secretary, she did. She destroyed all of his pages. He didn't want all of these things to be, as he knew, studied and then published and then discussed. She said, "I was perfectly happy to destroy his diaries by first shredding them and then burning the remains, because that is what he wanted." And again, for artists, again, start to think of that idea of artists' moral rights, not to have your work damaged. There might also be an artist's right to actually have your work destroyed if you are not happy with it then being distributed after your death, particularly if you're not happy with the quality of it. And Edward Albee, the American playwright, famously was a perfectionist, famous for Who's Afraid of Virginia Woolf. When he died in 2017, he left instructions in his will, very clear to his executors: destroy such incomplete manuscripts as soon as is practical after my death, and do not let anyone look at them before that. They're not to be studied, they're not to be critiqued in any way. He wanted these things destroyed because they were not good enough, they were incomplete. He left two plays, one incomplete, one that he had finished, had been put on show once and he was not happy with, so he was working on it again there. And his executors, well, we're still not completely sure, but it seems quite likely that they have followed his instructions. These, of course, would be very valuable works. They would be assets of the estate. But again, many have argued, well, the artist here, he said, they're not good enough. If they're incomplete, I do not want them seen by anyone. We've also had a very strange case of an artist actually destroying, or at least making inaccessible some of his artwork and then getting it back. So this is the artist Dante Rossetti, the pre-Raphaelite painter, and also very famous poet. And what happened here was his wife, Lizzie Siddall, when she died of an overdose, whether it was deliberate or an accidental overdose, he, of course, was distraught. And is famously, when she was the coffin lid was being put down on her, he put a Bible in with her, and he also put his notebook with his latest poems, the poems he'd written. Some of them he'd written for her in there as well, as a sort of dramatic, romantic gesture as well. She was buried, and about 5 or 6 years later, Rossetti starts to question his decision. He wants to write these poems. He tries to remember them. He tries to write them out again. He can't remember them. So his artistic agent suggests to him, well, maybe we could recover them from your wife's grave. And of course, at first he says, no, 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 and then allows himself to be persuaded. Now, there is a problem because she was buried in the family plot in Highgate, and that was with other members of his family, including his father had recently been interred there as well. And of course, to disturb her would be to disturb other bodies as well. But the Home Secretary at the time was convinced to give a license for exhumation, an unusual license in many ways, to recover a notebook. But he was a good friend of Rossetti's, so that happened. The coffin was exhumed, the book was recovered. Apparently Rossetti wasn't too happy because unfortunately the worms had done some damage to the book by that time, but he did manage to recover the poems, and he did publish the poems afterwards. But people found out it wasn't considered a very nice thing to have done. Modern issues with destruction of art have come about with our new forms of technology as well. So I just thought on a last idea, not to do with death, but to do with destroying property while you're alive. One of the problems with our new forms of property like non-fungible tokens is the fact that we are often being encouraged in the creation of these non-fungible tokens to destroy artworks. So famously, this drawing by Jean-Michel Basquiat was offered for sale in May 2021. There are a number of problems with the sale. First of all, those selling it said, well, you can reproduce it, you can do what you like, you'll all have all the copyright to it and everything else, which of course the Basquiat Foundation immediately said, no, you won't. And then the second point was, they said, look, when you buy this drawing, take digital images, and then take digital images of you burning it or destroying it in some way, record those on a blockchain as a non-fungible token, sell it, you'll make a lot of money. It'll make a lot more money as a non-fungible token than it will as a physical artwork. So this seems to be the idea, non-fungible tokens to be created by the destruction of physical artworks. And we saw this quite recently when we saw the destruction of a Banksy screen print again. And this is a screen print of his painting Morons, which of course is poking fun at the whole art world. This little group of technologists paid about $90,000 US for this artwork, and then filmed themselves destroying it, turned the digital film, of course, into a block on a blockchain as a non-fungible token, and sold it for just under $300,000 US. So they made a considerable profit. But they were saying this is an artistic statement in itself. It's interesting, of course, that in the original artwork, you have one of the characters saying, I can't believe you morons actually buy this. And that probably sums up a lot to do with non-fungible tokens and this sort of artistic expression at present. So just in conclusion, on the destruction of property, you can destroy your property in your lifetime with some limitations. You must not damage the property of others when you destroy your property, and you must not cause a nuisance. You may be prevented from destroying certain forms of special property, artworks. I think in particular, those ideas of artists' moral rights, I think could come into play. And then after your death, well, you may not be able to destroy your property. You will not be able to leave enforceable instructions in your will that you expect a court to actually enforce, because it will probably be against public policy. So the best way to do it, probably do what Churchill did. Give instructions to someone you trust, leave that property to them and allow them to destroy it. If you can't do what Monet did, and destroy it before your death. So thank you very much. I will now hand over to Michael to talk to you about adverse possession.
So the ownership of land is normally recorded in the title deeds and at the land registry. So wouldn't it be shocking to find that someone else has moved into your property And wouldn't it be even more shocking to find that that person is claiming that because they've been on your land, in your flat, for example, for a long time, that now the flat belongs to them? Well, that's the effect of the law of adverse possession. Someone who trespasses on private land for 12 years or more, in effect, becomes the owner of the land in place of the paper owner, in place of the person whose name is on the title deeds and who is shown as the landowner in the land registry. This is the effect of the limitation ordinance. The limitation ordinance gives owners 12 years to bring legal proceedings to evict squatters. That limitation period encourages owners to keep an eye on their property and to act promptly if they discover that there's some trespasser. And this means that the evidence is still fresh when the legal proceedings take place. So the doctrine of adverse possession plays a very useful role in Hong Kong's legal system, but it's controversial because it looks like legalized theft, and it's certainly open to abuse. Perhaps surprisingly, Hong Kong's courts often have to consider adverse possession claims. There were 3 cases in the first 3 weeks of 2022 alone, 2 of them in the Court of Appeal. And these are the 3 cases we're going to look at. The first was heard in the Court of First Instance, and the remaining 2 Court of Appeal cases. I'm going to briefly explain the general principles of the law of adverse possession, and then explain how those general principles were applied in these cases. For quite a few years now, I've been running the Hong Kong Landlord blog. I show the URL of the blog on this slide. If you go to the blog, you'll see posts that explain the facts of these 3 cases and the essential points from the judgments. So here's how I'll structure my presentation. First, I'll outline the essential features of the law of adverse possession. What does a squatter have to prove? What are the effects of a successful adverse possession claim? Then I'll briefly explain the facts of the 3 cases and then finally I'll explain the legal issues in each of the 3 cases. I hope we can use the cases to get a practical understanding of how the law of adverse possession works. So the first 3 bullet points show us the essential features of a successful adverse possession claim. The squatter has to prove that they were in possession of the land with an intention to possess for 12 years in the case of private land or 60 years in the case of government land. I'm going to explain what we mean by possession and intention to possess. The final 2 bullet points explain the main effects of a successful adverse possession claim. After 12 years, the paper owner loses the right to bring proceedings to force the squatter to leave the land. Not only that, the paper owner's title is said to be extinguished. So the first thing the squatter has to prove is that they've been in possession of the land for the full limitation period of 12 years. So what is possession? The English case of Powell and McFarlane is one of the main authorities on the law of adverse possession. And this passage from the judgment of Mr. Justice Slade explains what we mean by possession. I'll just read it. Everything must depend on the individual circumstances, but broadly, I think, what must be shown as constituting factual possession is that the alleged possessor has been dealing with the land as an occupying owner might have been expected to deal with it, and that no one else has done so. Possession also means having physical control. So is the squatter using the land as if they were the owner? Have they been using the land in the way that we might expect an owner to use it? If it's a flat, have they been living in it or renting it out? If it's farmland, have they been farming it? Who's been paying the bills for the land? Notice the last 2 lines of the passage. Another question is whether the owner has exercised physical control over the land. Are they in control of whether others can enter it? This extract from the judgment of Lord Justice Robert Walker in Simpson and Fergus also emphasises control over who can come onto the land as an essential feature of possession. So in this case, someone painted a white box on a road and placed a sign next to that box stating that that part of the road now belonged to them. But that person didn't stop other people from driving over the road, including the white box land. So they weren't in control. It wasn't enough for the person laying claim to the land just to place a sign next to it to say that it belonged to them. They needed to take control. So to sum up, these are the central ideas about possession. The squatter needs to be dealing with the land as an occupying owner would deal with it, living on it, farming it, paying the bills for the land. They've got to exercise control over who can come onto the land. And whether someone's got possession, proving possession, is a matter of fact, and the court looks at observable acts, or overt acts. So using the land, controlling the land, paying the bills for the land. And notice the final line there, that enclosure is the strongest evidence of possession. So building a fence, a wall, having a locked gate or door is the clearest possible evidence that you're in control of the land, that you're in possession. We have to distinguish occupying the land, being in possession of the land, from merely making occasional use of it. Just coming onto land occasionally to use it or take things from it is not enough. It's not the same as being in possession. And this is illustrated by this Waiwa Traders case, which involved some land on which there were lychee trees. And some people habitually came along and took fruit from the trees. And they claimed that after they'd been doing this for 12 years, that the land belonged to them. But the court didn't agree. This act of going onto the land from time to time and taking away the fruit from the trees didn't amount to taking possession of the land, taking control of the land. At most, it was persistent trespass. There was no sign that they had taken control of the land. When the paper owner, the formal owner, visited the land from time to time, there was no sign that anybody else was claiming to have possession of it. The second requirement for a successful adverse possession claim is intention to possess. In a way, it's puzzling that the squatter's state of mind should matter, but it does. So what is this intention to possess? This is a key statement of what we mean by the intention to possess, again from the judgment of Mr. Justice Slade in Powell and McFarlane. The intention to possess involves the intention, in one's own name and on one's own behalf, to exclude the world at large, including the owner with the paper title, if he be not himself the possessor, so far as reasonably practicable and so far as the processes of the law will allow. So it's an intention to possess, to hold on to possession. It doesn't require you to want to be the owner or to think that you are the owner. It's simply an intention to retain possession. And notice the final words, so far as reasonably practicable and so far as the processes of the law will allow. This is another explanation of the intention to possess, taken from a later House of Lords case, J.A. Pye. So here it's defined as the squatter's intention to stay as long as he can for his own benefit. The intention is the intention to possess, not to own, as I explained a moment ago. The squatter doesn't need to aim consciously at defeating the owner's title or becoming the owner himself, or even it's okay that the squatter should realise that he's not the true owner. This intention can be inferred from the squatter's acts of possession. So if there are clear acts establishing possession, that the squatter has been using the land as an occupying owner would use it, exercising control over it, then no separate proof is needed of the intention to possess. But where the squatter's actions are not so clear-cut, then there is a need to prove the intention to possess. As the third bullet point says, there is a need for compelling evidence or clear and affirmative evidence of the intention to possess. And again, the final bullet point, fencing or enclosing land where the squatter controls any access points is the clearest evidence both of possession and of intention to possess. What if, during court proceedings, the squatter is asked the following hypothetical question? Would you have paid rent, or would you have paid a license fee if the paper owner had demanded it? Now, in Hong Kong, a squatter's admission that they would have paid rent or a license fee, if asked, is fatal to their adverse possession claim. This was decided by the Court of Final Appeal in the CUHK case. In England, however, the House of Lords said in the J.A. Pye case that this admission was irrelevant, would not harm the squatter's adverse possession claim. So this is the relevant passage from the CFA judgment in CUHK. The 14th defendant's intention to pay rent if the owners had requested payment demonstrated that he was not intending to exclude the owner with the paper title, but showed that he was treating himself as enjoying possession under a lawful title from the owners. His intention to possess was not as of wrong, but was as of right. And the Court of Final Appeal referred to this English decision in Queen and the Secretary of State for the Environment ex parte Davis. So the idea seems to be that this admission that the squatter would have paid rent or a license fee if demanded suggests that they saw themselves as being in possession with the consent or license of the paper owner. And this would be incompatible, the Court of Final Appeal thought, with having an intention to possess, even though there was no actual lease or license. This passage shows that the English courts take the opposite view. So this is an extract from the judgment of the House of Lords in J. Pye, Oxford Limited. Once it's accepted that the necessary intent is an intent to possess, not to own, and intention to exclude the paper owner only so far as is reasonably possible, there's no inconsistency between a squatter being willing to pay the paper owner if asked, and his being in the meantime in possession. An admission of title by the squatter is not inconsistent with the squatter being in possession in the meantime. On this logic, it could even be argued that a willingness to pay rent or a license fee if asked reinforces the idea that the squatter had an intention to possess, that the squatter was determined to take any lawful steps to remain in possession. Remember, it's an intention to retain possession, not an intention to own. So English law and Hong Kong law take a different line on this question. The limitation period. The squatter has to establish that they were in possession with an intention to possess for 12 years in the case of private land, or 60 years in the case of government land. And the private land limitation period is 20 years, not 12, if the possession began before 1st July 1991. Now, I just want to tell you about Section 23 of the Limitation Ordinance. This says that if a squatter acknowledges in writing that the paper title owner is the owner, then that would stop the adverse possession. It would start the limitation period running again from zero. What are the effects of the expiry of the limitation period of a successful adverse possession claim? Well, the first two bullet points explain the consequences of a successful adverse possession claim. O, the paper owner, the formal owner, the person whose name is on the title deeds, can no longer bring possession proceedings, and those title is extinguished. The third and fourth bullet points explain something important about how adverse possession works. So S, the squatter, has a title, has an ownership interest in the land from the very moment they go into possession. So it's that possession makes them a kind of owner. But during the limitation period, until the squatter has been in possession for 12 years, the formal owner, the person whose title depends on the title deeds, has a better title than the squatter. The paper owner, before the limitation period has expired, the paper owner can bring proceedings to evict the squatter. So there's a concept of relativity of title. Both the paper owner and the squatter have got title, but during the limitation period, the paper owner's title is better. But after 12 years have expired, after the limitation period has ended, that's no longer true. Then the squatter's title is better than the paper owner's title, and thus the paper owner can no longer recover possession. But it's not the case that the effect of adverse possession is that the squatter takes over the paper owner's title. Rather, the squatter's separate title becomes better than the paper owner's title. So now I briefly want to explain the facts of the three 2022 adverse possession cases. So the Wu Sai Moi case involved land in Peng Chau. The plaintiff claimed to have been used it for farming, but the court thought that there was very little evidence of possession. So it was just a case of using the land from time to time, rather than taking possession. So that adverse possession claim failed. Lam Sai Wan, this was land on Lantau. The plaintiff had first of all been an employee on this farmland, but then when the paper owner left Hong Kong, the employee remained on the land and farmed it since the 1950s, and eventually the plaintiff's adverse possession claim succeeded. The Wu Yim Chung case was land in Sai Kung, used to store vehicles and construction materials. Originally, the squatter, the plaintiff, was the owner of the land. The squatter sold the land to somebody else, and so remained in possession under that lease. But when that lease ended, the plaintiff remained in possession of the land as squatter. That adverse possession claim failed. We'll see that there was the Court of Appeal thought there was lack of sufficient evidence that the plaintiff had control over the land. So now I want to apply the general principles of the law of adverse possession, the relevant general principles, to the facts of those cases. Possession, remember, involves dealing with land as an occupying owner would deal with it. If the land is farmland, then one obvious thing to do is to farm it, to grow crops, etc. But occupying owners don't necessarily actively farm all their land all the time. They may practice crop rotation, for example. So squatters don't need to actively farm all the land all the time, where this is consistent with the actions of an imagined occupying owner. Wu Sai Moi also involved agricultural land, and the court agreed in this case that there was no evidence that the squatter could be said to have been farming the land as an occupying owner would. Merely planting trees on the land was not clear enough evidence of possession or intention to possess. We saw that control over who enters the land is an important element of possession. In Wu Yim Chung, there was a road through the land, and the squatter didn't erect any kind of barrier to prevent third parties from entering the land along that road. There was evidence too that third parties did drive across the land to get to their destinations. So this passage shows that this lack of a barrier was fatal to the claim that the squatter was in control of the land. So I'll just read the passage. Bearing in mind the nature and use of the suit land, an open ground for storage of construction materials and vehicles, and its location in the new territories, an occupying owner would normally be expected to control access or secure entrance to the suit land. A failure to do so would naturally attract unauthorised parking or storage or other unauthorised uses, such as a dumping ground for construction waste or unwanted scrap vehicles. We saw that where the squatter's actions don't point unequivocally, clearly, to the squatter being in possession, then the squatter will need to work harder to prove possession and intention to possess. The cases talk of a need for compelling evidence. In Wu Sai Moi, the court decided that the squatter's actions of planting fruit trees on open land were not enough to clearly demonstrate possession, so there was a need for compelling evidence. But in this case, the squatter didn't persuade the court that they had possession and intention to possess. The court explains, though, that although there's a need in these cases for compelling evidence, the burden of proof is still the balance of probabilities. Is it more likely than not that the squatter had taken possession? I explained earlier that a squatter's written acknowledgement of title, of the paper owner's title, will start the limitation period running again because of section 23(1) of the limitation ordinance. But this is only true if the squatter gives the acknowledgement before the limitation period ends. In Lam Sai Wan, the squatter gave an acknowledgement of title after the limitation period had ended, and the Court of Appeal said that this had no effect. The acknowledgement was given too late to make a difference, too late to stop the squatter's adverse possession claim from succeeding. We saw that where a squatter admits that they would have been prepared to pay rent or a license fee if asked, then this is fatal to their case in Hong Kong, but not in England. And this was one of the reasons for the failure of the squatter's claim in Wu Sai Moi. The squatter's adverse possession claim succeeded in Lam Sai Wan. And at first instance, the judge ordered the land registry to register the squatter as owner. But the Court of Appeal pointed out that this was an inappropriate action, because that suggests that the effect of adverse possession is to transfer the paper owner's title to the squatter. But as I explained earlier, that's not how adverse possession works. The squatter has their own separate title arising from the fact of possession. So it was not appropriate to order that the squatter's name should be shown as the owner in the land registry. The appropriate action, I suggest in the final bullet point, is for the squatter to register the judgment at the land registry. So this is a reminder of the ground that we've covered. So I've explained the meanings of possession and intention to possess. I've explained the effects of a successful adverse possession claim. And I've used the 3 January 2022 cases to show how these principles work in practice. And the fact that there were 3 cases in the first 3 weeks of the year helped to illustrate my point that adverse possession is a lively and important area of the law in Hong Kong. Wong Tak Yu, the proposition that an admission that you would have been prepared to pay rent or a license fee if asked, that's fatal to your adverse possession claim, has been criticised, but it continues to be the law in Hong Kong. So thank you for your attention, and of course I'm looking forward to your questions.
Thank you very much, Michael. So we've had a couple of questions chatted in. We have got a few minutes left, but we're not bad for time. I think that's just about used up nearly the whole hour. But one question is, if someone is successful in a claim for adverse possession or by adverse possession, do they actually, what is their claim then against the government? Is it subject to the lease that's actually the person they're claiming against has actually got?
So the idea is that if the squatter defeats a private owner of land, then they haven't yet defeated the government, so the government is still able to bring, at the end of the government lease, the government could bring proceedings to evict them. So I think that's the position. But I do think this is a real puzzle, actually, because so that we can say what I've just said, we can say for sure that eventually, when the government lease ends, the government will be able to bring eviction proceedings. But what does the squatter own in the meantime? So we can call it a possessory title, but that's just a label. What is it really?
Good.
It's a title that can't be defeated by the paper owner who's been okay. But there is a bit of a puzzle, because it's clear that the squatter's title isn't a lease. It's clear to me anyway, I think, because a lease involves being a party to a contract, and the squatter isn't a party to a contract with anybody. They don't take over the ownership of the lease. They don't take over the lease of the paper title owner. So it wouldn't seem that they are a tenant. But actually, that's all that Hong Kong law has got to offer. That's the only type of ownership of land known to Hong Kong, really, is the lease. But it seems that the squatter doesn't have a lease, isn't a tenant. So that is a real puzzle. In England, where we've got freehold land, fee simple, so that the English authorities show that what has a squatter got? They've got a fee simple estate. But it would seem that can't be the answer in Hong Kong, because that's not that, Hong Kong doesn't recognize fee simple estates. So I think that's all we can say. It's a puzzle. It isn't a lease, but it can't be a freehold either, because Hong Kong doesn't recognize freeholds.
Right, thank you. I think we've got time for two questions. I've got more, but these questions came in early. So the next one is the title of the squatter to be regarded as good title for the matter of conveyancing?
Well, that is a matter of conveyancing law, and I don't claim to be, so slightly out of my thing, but I don't think so, because my understanding is that if you offer to sell a contract with good property with good title, you're going to have to produce a deed. You're going to have to trace your ownership back to a deed that's 15 years old. So I think, but I'm not absolutely confident, that if you want to sell land with, based on adverse possession, then you'll need to specify in the contract that is how you're going to prove your ownership. But then once you've specified it, that's how you're going to prove you're the owner. If the buyer accepts, yes, they're happy to have ownership proved in that way, then it's perfectly good. The squatter's title is perfectly good, nothing wrong with it, and you can sell it. But I think you need to specify in the contract that you're going to prove your ownership, in one way or another, by proving the facts of adverse possession.
Thank you. We've got a question from Shmuel Yerushalmi, who has asked, it's to both of us really, what's the situation with adverse possession on artistic property, so not land? Do you want to talk about this? Can you have adverse possession of personal property?
Well, only in the sense that, there's a limitation period to enforce any kind of right. So I guess that if you stole a painting,
yes,
and then
I think that's it. From the art side, I think that there are limitations on actions to recover property, stolen property. I mean, the general rule is stolen property stays stolen property, but there is a limitation on when the owner knows about the property and taking action there. I think there's a limitation. But it's an interesting thing because, of course, it's been raised in arguments about museums around the world not returning things that perhaps, in a way, because they've had things that perhaps were taken in unfortunate circumstances in the past, that perhaps there's an adverse possession claim or whatever else. Or again, I suppose you could look at in a way, if you're thinking of land and your explanation of land there, it's like Greece and the British Museum with the Elgin marbles, isn't it, really? They might still say that they are the owners, but the British Museum has got the possession of them, and that's good as against Greece at present, perhaps. There are a few other questions, but I'm afraid we really have sort of run out of time. I've been asked to just publicise a couple of upcoming events. So I think Jay, who's assisting us tonight, is going to share some PowerPoints on this. The next in our property law seminar series, we've got Andrew Lynn coming back again. Of course, he gave a great seminar last year about trustees. So now he's going to be talking about the hot topic again that everyone's still talking about, international cryptocurrency and crypto asset disputes. And that's on the 18th of May. We're just confirming the time on that at present, whether it will be a 5 o'clock or a 6 o'clock start. So we moved this one a little bit earlier. We thought it might be more convenient for people. So we're going to see what happens about that. And then the next one, Jay, I think you said was on Friday, we have the last in our present series of the Greater China Legal History seminar series, which is our Dean, Professor Lutz Christian Wolf, who's going to be talking about the development of China's inbound investment law. So the Dean has been telling me he's been working on his slides for a long time now. So I'm sure we're going to have a great talk on Friday. So please come and join us on Friday lunchtime. And then we've got the talk on the 22nd of March, which is by the Dean again on the Greater Bay Area and legal culture, a reality check. We were told earlier today that that was full up. But they've managed to, work something with Zoom. So we've got some extra places. So if you are interested, please go online and sign up for that quickly, because I think the places are nearly gone. That's on the lunchtime of the 22nd of March, where Professor Wolf will explain to us everything about the Greater Bay Area. So I think that's something we should all attend for that one. And then we've got the Centre for Comparative and Transnational Law, the Obligations Lab, will be having a talk on systems intentionality, which I'm not too sure what that really is, but by Professor Elise Bant on the 24th of March, another lunchtime talk. And now I know we've got, that was the last one. Thank you very much, Jay. So all that remains for me to do is to say thank you very much for Michael for joining me tonight to talk about this. Adverse possession is a really interesting topic. The other questions, by the way, we'll save the chat and I'll send them to you, Michael, because there were some other interesting questions as well on that. And then thank all of you for joining us tonight in the latest of the property law seminars. Hope you join us for our events in the future. Thank our colleagues for supporting us, in particular Jay for organising everything and organising us as well. And just to say again, look forward to seeing you in the future. We are CUHK Law. Bye-bye.